When one spouse has an extramarital affair or any sort of affair outside the committed relationship, it can be devastating for the other spouse. It can reflect a betrayal, a lack of honesty, and questionable judgment. The innocent spouse feels a lot of emotion. Those emotions can include anger and a strong desire for justice to correct the wrong that was done to them. But then they hear that Canada has a no-fault divorce and that the affair does not affect what orders a family court judge will make. None of the laws permit any sort of adjustment to compensate because of the affair. Is that true? To be honest, I have to give you that classic lawyer answer. It depends. This episode of the Ontario Family Law Podcast will explain when and how an affair can have an impact in family court. I'm Judge Schuman, a certified specialist in family law in Ontario, and I've been recognized for my concerns over children's law issues, difficult parenting cases, and complex financial matters. I'm also a mediator, arbitrator, and collaborative lawyer. I have a best-selling book, The Guide to the Basics of Ontario Family Law, which is available on the iBookstore, Amazon, Kobo, and in fine bookstores. If this episode covers topics that are important to you, you will likely find that book very helpful. The law does not give affairs any importance and little impact. Adultery does remain a grounds for divorce in Canada, so it is possible to get a divorce on the ground of adultery. But that almost never happens when a spouse can get divorced based on separation for 1 year. And, as I described in episode 88, physical separation is not necessary to establish that a couple is separated. And it is even possible for parties to be separated without one party knowing it. After the parties have been separated for a year, they can get a divorce as of right. But getting a divorce on the ground of adultery is significantly more complicated, costly, and takes a longer time. First, to get a divorce on the ground of adultery, the court must make a finding that the two people committed adultery. That means both the unfaithful spouse and the alleged adulterer or adulteress must be parties to the proceeding. The spouse making the claim has to sue two people, not just one, and be subject to cost consequences to two people if the claims are not successful, including the claim that the respondents committed adultery. In episode 51, I covered cost consequences of divorce. I also go into that topic in more detail in my book. The spouse claiming a divorce on the ground of adultery must prove that adultery took place. But Section 10 of the Ontario Evidence Act says that no witness in a proceeding instituted in consequence of adultery, such as an application for divorce based on adultery, can be asked questions or be required to give evidence about whether he or she committed adultery. Put another way, the spouse who wants a divorce on the ground of adultery cannot prove the adultery by asking the other spouse or the adulterer or adulteress about the alleged adultery. To get a divorce on the ground of adultery, the spouse requesting it must have another witness who saw the other spouse in the actual act of committing adultery. That may not be easy evidence to get, and that witness will have to testify at a trial about the adultery. With the current state of Ontario's family courts, it will take more than a year for a proceeding about adultery to get to trial, so it will be faster to get the divorce on the grounds of separation for 1 year. How long will it take to get divorced in Ontario? Check out episode 67 for that answer. The reason that Section 10 of the Ontario Evidence Act exists is because there can be legal consequences when a judge finds someone committed adultery. Technically, intentional interference with domestic relations is still a tort, so there couldn't be a spouse who commits adultery or the other party to the adultery could have to pay damages to the innocent spouse. For that reason, an adulterous spouse will not want to just admit to adultery. But I was not able to find one case in which a court awarded damages for that tort in the 40 years since the law allowed a divorce based on separation for a year. So it is more likely that claiming a divorce on the ground of adultery will result in the spouse claiming it paying the legal fees of the people who committed adultery than getting a divorce on the ground of adultery. I have referenced several other episodes in this episode. For more information about other family law topics, please subscribe, like this episode, and hit the notification bell. You may also want to pick up a copy of my book. In addition, you can get a lot more Ontario family law information on www.schumanlaw.ca and on my social media feeds. Check out my Facebook page. Follow me on Twitter and Mastodon at @SchumanFamLaw, and find me on LinkedIn, Blue Sky, and Threads. You can email me at john@schumanlaw.ca or call my office at 647-342-6775. Aside from that tort of interference with domestic relations, the fact of adultery does not entitle the innocent spouse to more money. 50 years ago, committing adultery gave rise to increased alimony payments. But since the mid-1980s, adultery is not one of the factors that judges are allowed to consider in deciding how much spousal support to order. Section 3310 of the Family Law Act says that the obligation to provide support for a spouse exists without regard to the conduct of the other spouse. In episode 30, I explained the factors that a judge must consider in deciding how much spousal support should be. Those factors relate to the sacrifices that each spouse made for the other spouse and the family and the economic needs of each spouse. Adultery does not factor into them. Section 3310 does say that a course of unconscionable conduct that constitutes a gross repudiation of the relationship can affect spousal support. To meet that legal test, there has to be several incidents of conduct that shocks the conscience of the court and that are designed to destroy the family. Judges have said that adultery does not meet that test. Adultery can be a symptom that a marriage is in trouble, not the cause. But in Bruni versus Bruni, Justice Quinn found that parental alienation did meet the criteria, and so a parent deliberately alienating the children from the other parent could have a huge impact on spousal support. Parental alienation is a complex topic that I have covered in other episodes and in several posts on www.schumanlaw.ca, as well as in my book. But in situations of parental alienation, you need to get legal advice fast to avoid a very bad outcome in court or arbitration. You can email me at john@schumanlaw.ca or call me at 647-342-6775. Having an affair does not impact parenting unless the children are forced to be involved in the adultery. Parenting decisions are based on what is in the children's best interest, not on the behavior of the parents that does not relate to parenting. To find out what factor judges do consider when deciding parenting, check out episode 59. The child support guidelines set out what the court must consider in deciding the amount of child support. The incomes of the parents matter, and so does ensuring that the children share in the lifestyle of their parents. See episode 89 and my book for more on that topic. Whether spouse committed adultery is irrelevant to child support. Whether spouse committed adultery also does not factor into the property division calculations after a marriage. There is a mathematical calculation that results in the spouses having the same increase in their net worth during their relationship. The calculation focuses on the net worth of the spouses on the date of marriage and the date of separation. Then it makes the change in the net worth the same. Adultery does not factor in. As I explained in episode 85, common law couples do not get to divide their property under Ontario's Family Law Act. Adultery is not even a legal consideration as to whether a spouse should move out of the matrimonial home after separation. Episode 91 covered the issue of when one spouse must move out of the house. With all these episodes covering important family law matters, make sure you subscribe to this podcast, like this episode, and hit the notification bell so that you know as soon as new episodes come out. Also, remember that my best-selling book has tons of 5-star reviews, and it explains all these topics in simple terms and directs you to the legal authorities you might need to use in court, arbitration, or even in mediation. So with the law excluding adultery from all the legal considerations, do affairs matter at all? Despite everything I've just said, the answer can be yes. Judges are people. Their feelings and impressions can influence their decisions. As much as the family laws are designed to turn decisions, especially financial decisions, into just objective calculations, and as much as family lawyers want court decisions to be predictable so that they can give some reassurance to their clients, judges find ways to help people they feel sorry for and to punish parties they do not like. One judge told me in court that family court is more a court of social justice than of legal justice, and so who the parties are matters as much as what the law says. Not all judges subscribe to that belief. Some work very hard to apply the law strictly and to give objective decisions, but some do not. So, unfortunately, this has led to a situation where parties and their lawyers try to make one party look like a saint worthy of a judge's compassion, and the other party look like an evil maniac who should be punished. In front of a right judge, that can pay off. Although the judges who try to objectively decide cases based only on the law find that really irritating. But if they are trying to be objective, all that judge can do is tell off the party for raising irrelevant considerations, but that will not affect the decision. While a judge who cares which party is more likable will be heavily influenced by such arguments. So, for a judge who thinks that having an affair says a lot about a party's character, the innocent party raising the affair can affect how that judge treats the parties, how easily each party finds it to move through the court system, what disclosure and other requirements each party faces, and maybe even the final outcome. However, as I went over in episode 36, judges often find other types of behavior more troublesome than whether a party had an affair. Judges are often heavily influenced by behavior that they can see, such as how a party acts in the courtroom, or whether a spouse provides financial disclosure. Judges often view whether a parent voluntarily pays child support as an indication of how devoted a parent is to the children. While some judges may see a spouse who committed an affair as having an inclination towards dishonesty or showing questionable judgment, other judges may view a spouse who complains about adultery as angry, vindictive, and irrational, as the law technically places no weight on the adultery. One of the biggest advantages to having a lawyer in family court is that good lawyers know the judges and what each judge likes and does not like. Lawyers also know how to point out the flaws in the other party's character without making their own client look vindictive or irrational. They can also help their clients take reasonable positions that judges like and link the opposing party to several instances of bad judgment. If you'd like to meet with me, either to represent you or give you some tips for your family court case, you can email me at john@schumanlaw.ca or call me at 647-342-6775. Also, being upset about an ex's affair can cloud a person's judgment and lead to them acting out of anger rather than reason. Sometimes the emotional upset can make it difficult for another otherwise great person to make decisions or move forward with their life or their court case. When a spouse is struggling emotionally, family court can be a bad choice that can lead to devastating results. Check out episode 60 for more on that. Canada has a no-fault divorce system. One spouse having an affair does not directly impact any of the financial calculations under the law. Just having an affair does not directly play into a judge's decision in a parenting case and in deciding who should look after the kids. But some judges still find committing adultery to be morally repugnant, an indication that one party is dishonest, is not trustworthy, or is otherwise unreliable. Some judges just may not like a person who has had an affair and may make it difficult for that party to succeed in family court. But other judges think an innocent party focusing on an affair makes that person look less innocent and more angry, more vindictive, and less worthy of compassion or favorable orders. Navigating family court can be tricky. Good family lawyers know how to navigate the court system and make their clients look good and make their opponents appear unworthy of receiving any court orders that will help them. Please feel free to contact me at john@schumanlaw.ca or the phone number in the description. And of course, to get a lot more family law information on parenting matters after separation, or information about child support, spousal support, other financial matters related to separation and divorce, and to understand how family court works, including an explanation of all the steps and the alternatives to court, get a copy of my book, The Guide to the Basics of Ontario Family Law. You can access it immediately on the iBook Store, on Amazon for the Kindle version, or you can download it for Kobo. Amazon can deliver the paperback version directly to your doorstep. Check me out on social media. And please subscribe to my YouTube channel and hit the notification bell to keep up to date. You can get the audio versions of the Ontario Family Law podcast on all major podcast services, including Apple Podcasts, Spotify, Google Podcasts, and many more. They're also available at www.schumanlaw.ca. Just look for podcasts in the drop-down menu. Thanks for participating in this podcast. We will get together again soon.